So what I want to talk about today is the role that civil law can play in dealing with faith-based disputes in family law in the United States. So I want to talk about the ways in which Jewish law authorities and advocates on behalf of Agunot have deployed various instrumentalities of the civil law to try and assist. But in doing that, first I want to set the context, which is looking at some recent developments in American law that have complicated it. And those recent developments involve initiatives in states across America at the state level rather than the federal level that have passed legislative initiatives that ban the use of foreign law in civil courts. And I'll talk about what foreign law means, and I'll talk about why these initiatives have been brought in and the implications that these might have for the range of strategies that advocates for Agunot have developed over the last 20 years to try and use the civil law to try and rebalance the bargaining power of women and men under Jewish law by bringing in mechanisms of civil law. So I'm going to focus on the United States, but before I do that, I want to talk a bit about Canada, because I think Canada is a bit of an object lesson of what moral panics about, in this case, Sharia law, might mean for advocacy for Jewish women using the civil law. So those of us who are from Canada are aware that in 2005 there was a moral panic about the possibility of Sharia law being imposed upon women in the province of Ontario. And we also heard in the presentation yesterday by Bettina and Deidre that the vast majority of the Jewish community in Canada lives in the province of Ontario. That most of them live in Toronto. Most of them live within a 20-minute drive of my mother's house in North Toronto. So it's a very concentrated community. So what happened about 12 years ago in 2005 was that a group calling itself the Canadian Society of Muslims, which is actually just one imam, sent out a series of press releases to the Canadian press saying that they were going to be setting up a private Islamic court of justice in the city of Toronto, and they would make themselves available for the resolution of commercial and family law disputes. And as in Jewish law, there is a notion in Islamic law that if there is a tribunal that will resolve your disputes in accordance with religious law, you have an obligation to bring those disputes to the religious tribunal. So this court, this Sharia court, would have allowed parties to name them as an arbitrator under the Ontario Arbitration Act and would allow them to resolve their family law disputes in accordance with Sharia law principles. This gave rise to a very vibrant debate within the province of Ontario and within Canada more generally about whether the creation of this kind of Sharia tribunal would be consistent with Canadian equality norms. And there was particularly concern from Islamic feminists and broader women's groups that women would be compelled to take their family law disputes to these tribunals, and that these tribunals would offer women inferior procedural protections and also inferior entitlements to maintenance, property, and custody than those that they would get if they went to an Ontario civil court. What was interesting about this is that this was only speculative. There was no Sharia law tribunal. There was just a press release. The only people who were applying faith-based arbitration to family law disputes in the province of Ontario were the rabbinical courts that were operating in Ontario that had been operating for 100 years. And the rabbinical courts sort of made that point. Hello, we're here. We've been having our determinations enforced under the Arbitration Act as valid awards, and there hasn't been a lot of problems. Just take a step back. But there, as I say, there was a moral panic, and there was a provincial inquiry conducted by a former Justice Minister, Marion Boyd, who said, also take a step back. It's possible to allow faith-based arbitration with appropriate judicial review. But the Premier of the province didn't go in that direction. He announced, on the contrary, there will be no religious arbitration in the province of Ontario. There will be one law for all Ontarians. So even after having rabbinical courts in place for 100 years, legislation was passed in 2006 that says that it is now no longer possible to enforce decisions of arbitrators that are based on religious law in the courts of Ontario. So according to the guidance that is now given to parties by the Attorney General of Ontario, they say, however, if the arbitrator makes a decision based on religious principles, so in this example on Jewish law, the decision is not a valid family arbitration award under the law. Both spouses could comply with the decision voluntarily, but the decision would not be enforceable if one of the people chose to take it to court. The court may only enforce awards made in arbitrations conducted exclusively under Canadian law. So what this means is if you want a Beit Din to resolve your family law dispute, you should still go to the Beit Din, and if both of you agree, that's okay. But if either one challenges it, it's not enforceable, unless the arbitrator has gone through a training in Canadian law that makes them a licensed arbitrator, and that they're only applying principles of Canadian law. They can't be applying any principles of Jewish law. So that was the fallout of what wasn't a concern about the enforcement of Sharia law. The impact was on Jewish law. And what that has meant in the province of Ontario is that the Halachic Prenuptial Agreement, the Rabbinical Council of America Agreement, which incorporates principles of Jewish law and would ideally empower the Beit Din to order $150 a day of maintenance unless and until the get is issued, is not a valid agreement under Canadian law. It could not be enforced in court, and people in Canada don't sign it. So, and people who come to Canada, let's say they move from New York and come to Canada, that's not an enforceable agreement in the Canadian courts. And it's beyond my mandate today to talk about what that has meant for Jewish law and Agunot advocacy in Canada. But if you look at someone like Yael Machtinger, whose work is on Jewish law in Ontario, I think her work suggests that it has had a conservative, regressive effect on how helpful the rabbinical courts in Canada are to Agunot and how sympathetic they are. So that's the framework for thinking about what a foreign law ban aimed at Sharia may mean for Jewish law. So then I'll talk about initiatives that have been going on in the US since 2010. Since 2010, there have been, sorry, let me just find this in my notes. There have been 37 of the 50 states in the United States have introduced bills that seek to ban the use of foreign or international law in state courts. And foreign law bans have in fact passed into law in 9 of these states, in Oklahoma, Kansas, Louisiana, Tennessee, Arizona, South Dakota, North Carolina, Alabama, and Florida. And I should say not communities that have big Muslim communities. These laws were not just generated out of the air. They're based on a template drawn up by an anti-Muslim group called the American Public Policy Alliance. And they have an initiative called the American Law for American Courts program. I can talk a bit more about why this might be even more relevant now, because some of the people involved in American Law for American Courts are actually involved with the new administration in America. The template that they have created asks each legislator to redefine what public policy in the state means, to include a duty, and this is a quote, to protect the state citizens from the application of foreign laws when the application of a foreign law will result in the violation of a right guaranteed by the Constitution of the state or the United States. So what this can mean in practice is that it would include enforcement of provisions of religious marriage contracts, like a prenuptial contract, and also prevent enforcement of an agreement to resolve disputes before a faith-based tribunal that would resolve those disputes in accordance with foreign law or religious law. The explicit objective of these laws is to prevent the enforcement of what this group describes as creeping Sharia law in the United States. They believe that Muslim Americans have an agenda to recreate America as a Sharia-compliant country, and that they seek to use the courts to do so. They caution that Islamic law discriminates against women and warns that its recognition in American courts puts the rights of Muslim women at risk. I believe that this picture both exaggerates the extent to which Islamic law is applied in the US, but also ignores the way in which Jewish law can be caught up with many of the same characterizations, that Jewish law also offers women fewer rights to divorce than American law, and may offer inferior property and maintenance entitlements and inferior procedural rights. And so paradoxically, this anti-Muslim discourse cloaks itself as a defender of religious women when a complete break of the nexus between what happens in religious courts and civil laws around divorce may harm the very women that it purports to defend. So I'll tell you a little bit about the history of these American law for American courts based initiatives. The first laws that were drawn up based on this model didn't pull their punches. They said they were specifically aimed at banning the application of Sharia. So for example, the Oklahoma law said, the court shall not look to the legal precepts of other nations or cultures. Specifically, the court shall not consider international law or Sharia law. Now, as you might imagine, if you know anything about American constitutional law, this law was immediately struck down. It was struck down as invalid by a federal appellate court on First Amendment grounds because it explicitly and intentionally discriminates against Muslims. Usually when you have a First Amendment case, it's like an incidental discrimination, but it's an apparently neutral rule that has an inappropriate or disproportionate impact on one religious group. But this one just says right on its face, we're discriminating against a particular religious group. And under American law, a law that discriminates among religions can only be sustained if it is closely fitted to achieving some compelling governmental objective. And the appellate court in Oklahoma said that the state could not point to even one Oklahoma case in which Sharia had been applied at all, let alone applied in a problematic manner. So that law disappeared. Tennessee also introduced a law that purported to criminalize Sharia organizations and made it an offense to conspire with others in support of Sharia. The act sought to delegitimize Islam as a sham religion and purported to define Sharia as a legal, political, military, doctrinal system combined with certain religious beliefs, which required adherents to overthrow the government of the state of Tennessee and the United States and replace it with a government based on Sharia. After robust criticism, this bill was later amended to exercise every single reference to Sharia and was ultimately passed as a bill barring support of terrorism. So, having learned from these initial disappointing forays, later versions of the anti-Sharia laws learned and don't explicitly refer to Sharia, but use a religiously neutral term, foreign law, with the exception actually of a law that was just introduced in Oregon this year, which does actually say Sharia. This has allowed the laws to potentially cover halacha intentionally or unintentionally, but indeed some legislators have attacked Jewish law directly. Draft versions of the Arizona law explicitly envisioned prohibiting the application of halacha along with Sharia, canon law, and what they called karma. In pleadings defending the explicit ban in the Oklahoma case, which I mentioned, which struck down the law, the Attorney General for Oklahoma also suggested that it was not necessarily discriminatory because they would be happy to use it against halacha as well as against Sharia. That Sharia was just mentioned for illustrative purposes, but it could be applied to other regimes. The potential impact of these foreign law bans on Jewish women and those trying to help them is particularly odd given that American law for American courts is the brainchild of a Brooklyn lawyer named David Yerushalmi, who describes himself as an Orthodox Jew. And in an interview with the New York Times, he acknowledged that these laws would have little practical effect in cases before U.S. courts, in part because Sharia is rarely implemented in U.S. courts. Rather, the primary and intended effect of such legislation is to demonize Muslims and Sharia law by erroneously suggesting that its doctrines are frequently in conflict with American civil rights norms, more than those of other religious groups. And this is a quote from the New York Times. For Mr. Yerushalmi, the statutes themselves are a secondary concern. If this thing passed in every state without any friction, it would not have served its purpose, he said. The purpose was heuristic, to get people asking this question: what is Sharia? So what implications do these initiatives have for Jewish law? And that's all, well, I'll head into the end. So Experts on the operation of Jewish law in the United States, like Michael Broyd, have argued in recent articles that Islamic law, if it starts to be practiced in the United States, has a lot to learn from the practice of rabbinical courts in America. And he's written a series of articles sort of developing that. And indeed, there are important areas of overlap. Both Jewish and Islamic law purport to provide religious and ethical norms that govern all areas of life. Both establish religious law tribunals to resolve disputes that arise between adherents based on these norms. And both express a preference for adherents to come to those courts rather than to civil courts. One area that Islamic law tribunals might learn from rabbinical court experience in the US is the way that civil law can be called upon to aid religious law tribunals and religious family law norms. There are a range of civil remedies that have been developed which support the resolution of Jewish divorce disputes precisely by having civil courts take notice of, respond to, and even enforce elements of Jewish law and decisions of rabbinical courts. So I'll just briefly talk about the different opportunities for doing that. So one is, there are 4 different ways. So one is that people in the US will often, if they think about it, will put a provision relating to delivery of a get into the separation agreement or into the divorce agreement that ultimately becomes filed as filed as an order of the court. So the parties will put in a clause saying, well, we agree to cooperate in delivery of the divorce. We will attend before Beit Din X. And if they fail to do so, there is the potential for that undertaking, either written into the document or an undertaking given in open court orally, to be enforced by the civil courts through a contempt proceeding or through an order of specific performance. The second way in which the civil courts have gotten involved in Jewish divorce disputes is the Lieberman Clause that we've been hearing about. There is a case, Avitzur, which was decided in the 80s, in which there was no agreement in the divorce decree, but they did have a ketubah that had the Lieberman Clause in it, and they argued successfully to the court that the agreement to take the advice of the conservative Beit Din to resolve their marital dispute was a binding obligation, and the court ordered the husband, in accordance with the provision in the ketubah, the conservative ketubah, to go and deliver the divorce. There have also been cases in which they have read a similar inference into Orthodox ketubah, even though it says nothing about a duty to go and resolve the disputes. There have been several cases in which courts in different jurisdictions have received expert evidence from rabbis who said, for example, agreeing to marry in accordance with the laws of Moses and Israel means you intend to resolve your marriage or dissolve your marriage in accordance with the laws of Moses and Israel, so he should be expected to go to Beit Din to do that. There have also been cases in which the court has gone further and perhaps inappropriately said, well, the husband is arguing that the wife has committed an act of adultery under Jewish law. He has to divorce her, so really he should be going to Beit Din. And the fourth way in which the civil courts in the US might get involved in rebalancing power under Jewish law with regard to marriage is the Halacha Prenuptial agreement. And Jeremy and I were recently on a panel that his Aura Fellows organized at Brandeis, and we heard from Rachel Light, who was the plaintiff in the first case that found that the Halacha Prenuptial agreement is enforceable in America and does not, it's a lower level course, it was a preliminary motion, but they had signed a halachic prenuptial agreement. The husband declined to cooperate in delivery of the get. She went to the court in Connecticut in 2012 and asked that they enforce the agreement, and it was a slightly different one that's in use than what is in use now, in which the husband, it doesn't require them to go back to Beit Din. It just says the husband will pay $150 a day from X time when the get has been requested. And the court said, that seems perfectly enforceable. We don't know how, the Jewish law might have been his motive for signing this document, but we don't need to know anything about Jewish law to say, you know, the triggering event has happened and we can count to 150. We can order that under neutral principles of American contract law. So that's also a helpful resource that is at women's disposal. So what does all this mean? Those are the ways in which civil law might be of assistance. what does the passing of these foreign law bans mean? It's odd, it's disingenuous, but is it harmful? If you had asked me a few years ago, when I started looking at these set of developments, I would have just said, no, it's just kind of strange. Until 2014, because in 2014, the foreign law legislation was passed into law in Florida. So as I mentioned, all the other cases, all the other situations involved communities that didn't have big Muslim communities, but they also didn't have big Jewish communities. But in May 2014, the law was passed in Florida. Florida is different. Florida has approximately 640,000 Jews, 3% of the state population, 9% of the Jews in the US. And the effect of the new law might be to require a court to reject contractual provisions that select a forum that will apply foreign law to family law disputes, including divorce, alimony, division of marital assets, child support, and child custody, if the regime doesn't offer the same benefits as Florida law. And they took submissions from rabbinical court experts about this. Avi Helfand from Emory, for example, oh no, from Pepperdine, sorry, argued in his submissions to the Florida legislature that Jewish law could be characterized as foreign law under the definition that they had in mind, because the state of Israel declares that marriages and divorce of Jews within Israel are governed by Jewish law. Thus, Jewish law is in fact foreign law of a foreign jurisdiction. And he suggested that the effect of passing this legislation might be to void all family law related contracts under Jewish law and to vacate all family law decisions issued by rabbinical courts. Moreover, Florida courts might not recognize marriages and divorces from Israel or child custody arrangements that account for Jewish law. And most importantly, he said, and I agree, it might render the halachic prenup unenforceable because it incorporates aspects of Jewish law, like the Agunot provisions of $150 a day. The Florida legislature clearly tried to calm these fears, and in the preparatory documents that, if you look at the legislation online, they have all the evaluative studies that they did beforehand, and they try and draw a distinction between Islamic tribunals and the Beit Din of America, saying the Beit Din of America has great procedural protections, which might be true, but all Beit Din are not the Beit Din of America. It also doesn't talk about the substantive law differences between American law and Jewish law in terms of access to divorce. So it's not sort of clear to me that it wouldn't apply to Jewish law. And maybe that's not a bad thing. This is the point in my notes in which I say Susan will say this is not a bad thing. But it is a crude tool, and it's a crude tool that would mean both that unhelpful discriminatory decisions of rabbinical courts couldn't be enforced, but it also means that helpful initiatives in rabbinical courts could not be enforced. And I'll just conclude by pointing to one suggestive case that's been decided under the Kansas foreign law ban, and it involved a Muslim couple in which there was a mar agreement. So there was an agreement that there would be, it's like ketubah money, there would be a financial settlement placed with the wife on the advent of divorce. And I should say this is obiter. This is not the basis of the decision. They based the decision on the fact that they didn't have an adequate translation of the Farsi agreement, but they said in passing that the foreign law ban was something that might have prevented them from enforcing the mar at any rate. And this was a short marriage, so under American law, she would have gotten quite a small maintenance entitlement and property division, whereas this mar agreement she'd signed would have given her several $100,000. And they declined to enforce the mar agreement. And the court suggested that it would decline to enforce a Muslim woman's rights under the mar or prenuptial contract, in part because this protective clause gave her deferred dower on divorce to compensate for the no maintenance that she would get. And they said they wouldn't enforce this because this was part and parcel of a system of law that disadvantages women. They rejected evidence that the mar provision within an egalitarian system was an egalitarian remedy that was attempting to improve her position. But the court said the whole system of Islamic law is obnoxious to the equal rights based on gender that we want to impose in Kansas. And they also refer by analogy, which is not a very good analogy, to the ketubah and say, well, our understanding is the ketubah works the same way, so we probably wouldn't enforce ketubah money either. So what I want to conclude with is saying that it's suggestive, it's interesting, but how harmful is it? Well, if we look at the Canadian example, it has meant that calling into question the capacity to enforce something like the halachic prenup has meant that people don't sign them. And Professor Galinkin was talking in his piece, and somebody else was asking me yesterday, does the halachic prenup work? There's only been this one case in 2012 in which it's actually gone to court and been enforced. But I want to suggest that it does work, but it doesn't work by being enforced. It works because it creates, it's a heuristic device. It educates about what appropriate behavior is. It establishes expectations. It establishes internal norms. So for example, in the piece that Ben shared, which says you have these obligations under Jewish law. For the most part, that's how law works. Mostly law works not by having to go to court or not by a police officer catching you and punishing you. It works because you internalize those norms and you govern yourself in accordance with them. So the halachic prenup, it's kind of like a stop sign. And the stop sign is not working. You don't determine that it's working by the fact that there's a policeman who jumps out from behind a bush every time you pass through. You determine it works because it leads you to control your behavior yourself. So to that extent, having expectations that the halachic prenup might potentially be enforceable, and that is a valid norm that's recognized by your religious community and your broader community, that's an important resource. And it would be a shame if these foreign law bans prevented that resource being available to American women. Thank you.